The collaboration working with the library especially has been great. Thank you. The second summer of our housing related series, and we appreciate the extended partnership on that, and working with others, as you can see at the bottom of the flyer there, Fairtide and Kittery and YCSA here in York. As Carrie mentioned, I'm the Housing Innovation Manager for the for YCSA and the Health Officer for the town of York. This will be our second summer of housing related webinars that we'll be doing through September, as she mentioned. This first one today will be about being a landlord, what the roles and responsibilities are, what the legal aspects are, and what some of the incentives are for being a landlord in our area. And I want to thank you for taking the time to join us today. To preface this housing seminar was brought to you by a joint grant received from Maine Housing by YCSA and Fairtide and Kittery. The Housing Navigator Pilot Program was initially established through LD 1733 as a 2-year program, and fortunately we were able to get funding for a 3rd year. The navigators for this program work with families experiencing or at risk of homelessness in obtaining housing and assisting them in maintaining stable housing following lease up. The 3 major components of Housing Navigator Pilot Program are landlord engagement, pre-tenancy assistance, and housing stability services. Today, again, we're going to cover those roles and responsibilities of being a landlord, as well as some of the incentives out there and a lot of the resources that folks may not realize are available to landlords. We want to make sure that we're helping you as best we can. So we've collected your questions during registration, and I shared those questions with our speakers who will be weaving them into their presentation. But if we don't get to your question today, feel free to put it in the chat. We have everyone's contact information. We'll reach back out with a copy of this presentation and answer for your question. You can also schedule a free consultation with me to talk about your property's potential to create a rental unit. Going through YCSA's website, you can sign up online or give me a call. I'll have my contact information up here in a minute. We also will put this webinar up on the library's YouTube channel, as well as on YCSA's Housing Solutions Library, where you can find some of our past presentations. So again, this first one, want to be a landlord, 12 to 1. And as I mentioned, one of our presenters is in court right now. So we have changed our agenda just slightly. So he will be presenting last. But as we move forward, here's a brief agenda for today. I will give an introduction to the Landlord Engagement Initiative, and then we'll go to Elaine, who works for Maine Homeworks, and we'll be doing the fundamentals of being a landlord. And then we'll go to Julie. Mike is still in court, and then I will follow up with talking about some of those other resources. As I mentioned, this webinar comes from a joint grant through Maine Housing and Fairtide. This program allows us to house people with a housing voucher. And if you're interested in being a landlord, you can get up to $2,000 in immediate incentives for signing up and leasing with us. That's for a 1-year lease agreement with someone who has a housing voucher. We provide the case management and wraparound services to assist to make sure it's a good match and that we're providing support to both the landlord and the tenant. I have a huge list of housing related resources that I'm going to be sharing with a follow-up email, as well as on our website. And I don't want to get too far into the weeds because we've got some great presenters here. But we're going to start with Elaine. Again, she comes from Maine Homeworks, and she'll be talking about the fundamentals of being a landlord. So I'm going to pull up her presentation, and hopefully you're able to
again, my name is Elaine Richer, and I teach a 2.5-hour program to people who may be at the earliest stages of buying an income-producing property, to those people that have already closed on their purchase. Sometimes I have students who have owned a property for a number of years, and they want to get an update. So that's kind of who I'm working with. As I said, it starts from people who have no idea that they want to buy it, but thinking about it, all the way to somebody who's been a landlord for quite a while. What I first talk about is the advantages and disadvantages of being a landlord. Go through that and ask these students actually to give their impressions of what they think, with some of the reasons that would be advantages for them. Where do they see some disadvantages? So if you go to the next slide. So the first thing we talk about is what do you do before you buy? Well, I suggest that the first thing that they do is they hire a buyer agent. And that's somebody who has experience not only in being a real estate agent, but has experience in multi-units. One who specializes in it, they own it, or they've taken courses in it. Because these are the people that can help buyers with the type of financing that's available out there, building inspectors that they might choose, and review the property disclosures that come with every property. And the next slide, don't move it though. And the next, no, let's go back. Yeah. And the next slide, we're going to do due diligence. But before we get to that one, the third thing on here is reviewing the numbers. Whenever anybody is thinking of buying a multi-unit, they need to look at all the numbers. The banks are going to finance it and they'll say, yes, you are qualified. But you need, as a buyer, to look at that and say, is this going to make sense for me? If I take my monthly income and I mortgage, and then I expense out my mortgage expenses and my property expenses, do I have a positive or negative cash flow? Usually when people start, it's going to be probably a negative cash flow, but hopefully they go on. And what I also suggest for them is to do it monthly, because if you're just doing it, you know, looking at your checkbook and saying, oh yeah, this looks good, it may not tell you the whole story. So I suggest that buyers, for the first year at least, or maybe beyond that, is to do a monthly reconciliation to see where they actually stand. When they feel good about that, then I'd say go quarterly and then do some quarterly, comparisons. The last thing on this is review the leases. The financing program that they're going with may demand that they take possession of a unit within a certain period of time, say 60 days. And sometimes they're not aware of that until they're ready to close. So they should be asking the lenders, is there anything I should know about this before I close on that? And so they want to really check also with the status of their security deposits, and to see, did the owner pay back any damages or back rent to the tenants that are existing there. So they know exactly when they close how much money is coming their way and what they're, exactly what they're going to be charged for going forward. If you go to the next slide. Due diligence. The first thing I have on here are building inspectors. Now, I know many buyers who are trying to compete with other buyers will decide not to have a building inspector because that will put them at a disadvantage in their bids. So I understand that, and I tell them, look, you may not be able to get a building inspection prior to it, but please make sure you have a building inspection right after you buy it, just to find out exactly what you have bought. I mean, you can look at the building, but you're not quite sure what are the pluses and minuses of this building. And when you're choosing a building inspector, they're not licensed in Maine, but might belong to an organization that certifies the building inspector. We have a couple of different ones that are out there that I've mentioned on there. There's ASHI, American Society of Home Inspectors, and then the National Association of Home Inspectors. If you go on their sites, first of all, they're going to steer you toward a building inspector that's in your area. Also, they're going to ask you what you're buying. You're buying a single family or multi, and they'll put a building inspector who has that kind of experience in touch with you. You can also ask your real estate agent for their references on who they would suggest you use for a building inspector. Second one is code conformance. I always suggest that the buyer go and talk to the code officer in their particular town that they're buying in. Check on the zoning to see what are the permitted uses, non-permitted uses. there is of course, there is a state building code and there is a state fire code, but each town can add to that. And so they really need to see exactly what that town is going to require beyond what the state does. And a lot of people think that they're following state code on both the code, building code and the fire, and they find that there are a lot of other things that they should have done. The third one on there is check on insurance costs. As soon as possible, a buyer should be checking to see what it's going to cost them for their monthly premium. And it is based on a number of different things. First of all, it could be on claims the buyer made, claims that were on the property that they're about to buy, and also on the type of rentals they will be using. So, for example, I have summer and winter rentals, which means that there is probably a week or two between. And because the property is not being used for rental during those 2 weeks, my insurance goes up because there's more of a chance of nobody being there. This could be a fire. This is what the insurance company says. So the other thing is some of the people might be doing an Airbnb. They may be doing it seasonal like I am, or they may be doing a year round. So that will also determine your insurance cost. So it's a very good idea as soon as you find a property that you go ahead and check on the insurance costs. I have on the oil tank spills, and the reason I put that on, I took a course not too long ago. And one of the things that we had for a topic was oil spills, and that was presented by a person from DEP.
Get me off of this thing, will you?
Excuse me? Are we talking? So on the oil tank spills, DEP says there is an oil tank spill at least once a day for the entire year. There's going to be one. And that is pretty bad. And in many cases, because the oil tank is corroding from the inside, it's not known until later on when there's, a lot of oil spills on the floor. The last one under this is fees to municipalities. There are certain towns that are going to be asking for additional fees for people who are renting their property. I live in Old Orchard, and it may be a little different than anywhere else, but I'll just give you a little heads up on what's going on here. When you buy an income producing property, the first thing you're going to have to do is check with the code officer in the town and have him come out and do an inspection. Now, they don't do an inspection prior to you buying it, so you have no idea what their concerns might be until they get there. Once they have decided that everything is okay, or maybe you need to do some work on the property, and that's done, they will issue a license, and that license has to be renewed every 2 years at a fee of $500. Now, that probably is a little unusual in Maine, but what we're finding is that most towns are considering additional fees for rental property. And I think what you want to do is check with the town to see if that is even on, the radar. Okay, if you go to the next slide. Legal requirements. I've got 3 types of disclosures in the first section here: energy efficiency disclosures, lead paint, and radon. And my suggestion is all 3 of them should accompany the lease that you're going with that particular tenant. Now, the energy and efficiency disclosure should be signed by the buyer, by the tenant, prior to receiving a deposit or signing any type of a lease. Now, in that disclosure, it talks about what type of insulation would be in there, what type of appliances, and what they would expect is the tenant and the landlord would sign the bottom of that. The tenant would get a copy. According to the law, the landlord has to keep that for 3 years. The lead paint, if the property was built prior to 1978, a lead paint disclosure must be given to the tenant. And again, it should be given to him before he signs anything. Now, one of the things that is probably not given as much, people are doing the lead paint disclosure, but according to the law, you need to make sure that they also have a pamphlet, which is protecting your family from lead paint from lead paint poisoning. And the pamphlet is available through the EPA. And that might be something that you'd want to make sure you have on hand. And the third form is the one on radon. That first went into effect in March of 2014, so it's been around for 10 years. If it was done in 2014 and there was no mitigation system put in, this is the year in which a tenant can ask to have the landlord redo that test, because there's a 10-year period between 2014 and 2024. So if it's been done within 10 years, the landlord does not have to do it, but if it's after the 10 years and the tenant requires it, the landlord must give them a new radon test. Security deposits. There's a maximum of 2 months that can be required of the tenant. And one of the questions I usually ask the students is, have they ever paid a pet deposit? And a lot of them will raise their hand. I'm going to tell them that there's no such thing as a pet deposit. It's a 2-month maximum, and that's it. So there shouldn't be anything like a 2 months plus a pet deposit. That would be illegal. On rent increases, the reason we go over this one is that many times in the law, the number 30 comes up, but this is not where it is in the rent increases. Rent increases need a 45-day notice unless the rent is going to increase more than 10%, and then they need a 75-day notice. At the very bottom of that, I have lease or rental agreements. And some people do tenant at will, which means that either the landlord or the tenant can give a 30-day notice that they want to end that tenancy. And that can happen. But if you have a lease, it's usually for a year. But my suggestion for people that even if they have a tenant at will in their as a landlord, that they have them sign some kind of an agreement that would be very similar to a lease, but it would terminate again with that 30-day notice to either one. So the last thing on that page is maine.gov. And that is the site I tell most of my students that this is a place where they can get lots of information. The two types of information that I'm going to suggest that they get, one of them is called the Attorney General's Model Landlord Tenant Lease. So those people that are looking to have a lease and they don't know what to use as a landlord for the first time, this is probably the best thing that they could get. It doesn't mean that they can't have their own attorney do it. And the second one is Consumer Rights When You Rent an Apartment. So again, that one is called Consumer Rights When You Rent an Apartment. And that again is found on maine.gov. And it has several things in it. I'll go through a couple of them. Rent increases, abandoned property, unfair rental contracts, landlord smoking policies, all that would be in there, because there is no consumer rights when you actually rent an apartment to a tenant. This is for the consumer, but you could get as much information from that as if it was written for you. Now, the last slide, you go to the last one. This one is on service animals, and this has become an issue, and it's from the Human Rights Commission. they're considering a problem because people don't know what the rules are. First of all, when we talk about service animals, there is really only one kind of a service animal, and that is a service dog. And a service, if you have a service dog, if your tenant has a service dog, there's no documentation that is expected. They don't have any documentation. The dog does not wear a vest. If you cannot tell what the disability might be, you can ask the tenant, the tenant that is presumed to come, what has the dog been trained for? And that is about it. As far as assistance animals, then that might be a little bit something that you are not familiar with. Assistance animals in other states are called emotional support animals, but in Maine, they're called assistance animals. And there can be documentation with assistance animals, and the animals can be a cat, a dog, a bird. It could be any type of animal. But if the person who is asking for an assistance animal is determined that it's necessary for them to have one, what they're going to do is get documentation, and they can get that documentation from a physician, a psychologist, a nurse practitioner. And the idea behind the assistance animal is what they provide: emotional support, well-being, comfort, or companionship. So what I've pulled up is what I think is probably the most questions I get in a class, but again, I did not do a 2.5-hour class with you, so I know that there are other things that have not been discussed, but thank you very much.
Thank you so much, Elaine. I really appreciate that. There's a lot of new information there that I myself did not even know. So thank you. We will circle back with questions at the end for you. And because one of our presenters, unfortunately, is still in court, we're going to change our agenda slightly and pivot to Julie next. Julie Vanderpool is also a housing navigator at Crossroads in Portsmouth, and also a licensed realtor who can practice in Maine and New Hampshire. So I will take it away, Julie. Thank you.
Hey everybody, how's everybody doing today? I guess you can't really answer me. So I'm going to go over, it's actually kind of good that we rearrange this because some of the information that I'm offering and sharing just piggybacks right with what Elaine was talking about. I'm going to go over landlord opportunities and best practices. So some things I wanted to talk about first were, this is not going to be all, but some common, maybe a couple not so common rental types that we see. Attached to main dwellings. These can either be attached by common walls or floors, like a basement or attic unit that is attached to your main house or studio. Could be a side-by-side duplex or triplex or more. And then also we're seeing some rooms for rent with shared common spaces. You might have a couple of bedrooms that are rented, and then folks share living, kitchen, and laundry spaces or outside common areas. So those are some variations we can see. We also see some detached from main dwelling rental opportunities. Those are units that may be on the same property, but in or above in a detached garage, maybe a standalone unit or building on or off the main property. ADUs are another thing that are a hot topic lately. Accessory dwelling units is what that stands for. And really those can encompass a lot of things depending on the area that you're working with those, but it's a converted space that folks are now using for living. It might have been a shed before or a storage container of some sort, and they've converted it to living space. So best practices for potential landlords. Some of this stuff is just going to piggyback right with what Elaine said. When looking at potential properties, maybe or whether you're looking or whether this is something you already have. Can I rent this is going to be a question that you're going to ask, meaning, will the municipality that I live in allow me to have this rental property? It will be important to contact local zoning offices. Those can either be in a town office or a county, depending on, again, the area that you're renting. There are other deed restrictions that can prohibit your ability to rent, and those could be in the form of an HOA or other deed restrictions that would be attached. My advice is always skipping to the bottom, professional advice. So I'm gonna encourage folks at every opportunity to seek out the professionals that can help them navigate gathering that info. In this case, it would be your local zoning offices. You could also enlist the help of a buyer's agent or a local real estate agent to help with some of that. Market analysis, again, professionally speaking, this is something that your realtor could do for you, but you're going to examine current rental rates for similarities. Utility trends. Are most of the units in areas renting fully furnished with all utilities included? Is that easier for you? Is that more beneficial, or are you just going to rent an empty space and let somebody else deal with utilities and furnishings? It's kind of important to pay attention to the area rents. You want to stay current with market, but you also want to be able to keep your affordability in line as well. Sometimes those don't jive. We're seeing a lot of things that are current with the market, but they're falling short in the affordability. So you just kind of want to look at what else is out there and then find where your place is going to fit in. Elaine talked a little bit about financials, not just the amount of rent that you're going to collect, but all the costs associated with operating that property. What are your goals for the expected rental income? Can you afford to rent it full time? Is that something that makes sense, or is a hybrid something that's going to make more sense for you? What are the other financial obligations that you have to meet in order to make that successful for you and your tenant? Something else that I think folks overlook or underestimate are repairs, maintenance, and service calls. What's the plan for those when they happen? Too many times we see that landlords are definitely interested in getting the property ready to rent, and all of the things leading up to it so that they can collect rents. But it's more than just collecting rents. You're providing a service, and that service requires maintenance from time to time. It requires emergency service from time to time. So thinking about that and having a plan for those ahead of time will definitely make things smoother. My plug about professional advice, legal contract forms, taxes, changes in laws, attorneys, accountants, municipal offices. Those are all professionals that you can seek out advice from. Realtors also have access to some standardized forms that are available. I'm also a fan of Maine.gov and the Real Estate Commission in general. They have lots of info. But wherever you can, I would encourage you to seek out professional advice. That's going to be your best bet always. Other things to consider that I see coming up for folks that are new to leasing, things like common areas. If the rental is on your property, or even more so if it's connected to your property, are there areas that will be shared? And then what's the maintenance of those? What are the maintenance expectations of those shared spaces? Those could be things like yard work. Are you taking care of that, or are they expected to maintain a certain portion of their yard, trash, yard decor, things like that, that we don't really think about until somebody's moving in and starting to add their own personal touches to things. Pets, not just the service animals and assistance animals, but just household pets in general. Are you planning to allow them? Will they share space with your animals if you have them? Does your insurance company have breed restrictions or size limits? Those are things that you would want to check in with your insurance company, also an HOA if applicable, to see if there are any of those types of restrictions before you just allow pets in general. Rental assistance programs. Those are things that are available, like what Amber was speaking about, with what they do in Fairtide. There's some other programs that I've worked with on the New Hampshire side, but seeing what's available and understanding what types of assistance are out there so that you can determine what types of assistance you may want to accept as rental payments. Navigating what those programs consist of and learning about property inspections that might have to take place, and then making sure that your property is up to par and ready and prepared to pass those inspections. A lot of those programs also can offer some incentives to new landlords. So it's a good idea to know what those are. You may have an opportunity to take on a new tenant, and then also, in addition to receiving that rent, receive other financial benefits or other benefits in general that will help you be a better landlord. Other considerations when thinking about prospective tenants. What are you going to do with credit history, criminal history? What are your thresholds for that? With my work with Crossroads, we deal with a diverse community, and we have people from all backgrounds, good credit, not so good credit, no criminal history, some criminal history. And when I am reaching out to landlords, one of the things that I do is I try to pinpoint what their thresholds are for that. Some folks are not comfortable with any criminal history. Some folks understand that life happens and sometimes people make mistakes, but they've learned from them and moved on, and they're open to more. But thinking about those kinds of things before you are actually a landlord and looking at potential folks to lease your property, just have a good idea about what your thresholds are for that. What are your income requirements going to be? Typically, we're seeing reasonable income requirements at 2.5 to 3%. I'm sorry, 2.5 to 3 times your income as an income requirement for rent. I'm sorry, I still messed that up. 2.5 to 3 times the rental amount is what you would need to make. That's the income requirement. You can set that yourself. That's not something that's, there's not a formula for that you have to follow. However, you want to kind of keep in mind what is considered affordable is somewhere around 30% of someone's income. So if you see that your rent and their income are out of balance and it's closer to that 40 or 50%, that's probably not going to be the best fit for either. There might be some struggle in paying that. So it's just kind of a good idea to see what kind of income requirements you're going to have. And then compatibility. I'd say that to cover a lot of things. You don't necessarily have to, you don't have to be best friends with your tenant. There doesn't have to be a friendship there. There's definitely a business relationship. You're providing housing, they're paying for that housing. But it is important to consider some compatibility issues that might come up. Things things like work schedules that's a really easy one, especially if you have an attached dwelling unit and you have someone who is renting that works nights and you're at home during the day and you have kids. That might be something to consider as a potential compatibility issue. So you might ask those questions and see how a potential tenant may feel about schedules. Again, there's no hard or fast rules about that. It's just kind of thinking outside the box and how potential problems could arise and how you could avoid those altogether. Wrapping up, I just want to remind folks that you don't have to go it alone. There's a lot to consider when you are making the decision to lease out your property. It can be very rewarding. It can also be very challenging. Nothing's perfect. And anytime we are dealing with humans, whether those are landlords or tenants, there's bound to be hiccups. But support is available. I would encourage you to reach out to a real estate professional. Housing authorities can be of some assistance as well. Municipal and county offices for your zoning questions, permitting questions, if you have to make repairs. Insurance agents can talk to you in terms of breed restrictions, fire codes, those sorts of things. There may even be some discounts available. Attorneys, specifically, attorneys that practice real estate law would be good in terms of any addendums you might have to draw up. You want to just be careful that you're wording things appropriately. Accountants on the tax side of things. Banks are another good resource for potential landlords that may need some financing options to either expand their living arrangements to make room for this or to make some adjustments. Housing liaisons like myself or navigators like Amber are also good contacts, and other incentive program coordinators. And that is it for me.
Thank you so much, Julie. It's a lot of great information, and I'll be sure to be sharing this as well. Once we get this formatted in a way that we can share with everybody who wasn't able to virtually use the login there. Our next presenter is Michael Spalding. He is a staff attorney for Pine Tree Legal. And Mike had a pretty busy schedule today, was in court, and so we appreciate him taking the time to fit us in and to talk about some of those really important legal aspects and rules actually that are mandated by the state if you're going to be a landlord. So I'll give it to you, Mike, and I believe you are a co-host, so you're able to pull up your presentation, or I'm happy to pull it up.
Well, so yeah, my laptop just died, so I switched to my cell phone, and I don't have, I don't think I could really do the presentation myself while being on the cell phone. So can somebody do the presentation for me and I will just talk?
No problem. Let me just get that pulled up unless Carrie's got it there in the background, and we will pivot and get that shared real quick here. Okay.
All right, very good. Thank you. My name's Mike Spalding. I'm an attorney with Pine Tree Legal Assistance. I am an eviction defense attorney. I don't represent landlords. So if you do decide to become a landlord and you do someday do an eviction, we may be on opposite sides of the case, but I do think I have some useful information for you today. But again, this is just legal information, not advice. You should always consult an attorney, and probably an attorney who specializes in representing landlords. I'll take the next slide, please. So yeah, I'm just going to go over the basics of what exactly is a tenancy, the eviction process, and some kind of special landlord-tenant laws that often present questions or for both landlords and tenants. Okay, so real basic here, right? What is property? The metaphor that law students are often given is that property is a bundle of sticks, and each stick represents a different right that the owner has. So in this bundle of sticks, you have the right to sell, you have the right to refinance, you have the right to dispose of it in your lease. And one of the sticks is the right to possession. And when you enter into a tenancy, what you're doing is you're giving away the right to possession stick to a tenant in exchange for compensation. And why I mention that is because what often happens, or where I think smaller landlords can get into trouble, is they have a feeling that because it's their property, they can do whatever they want with it. And I try to emphasize that in a certain sense, you can do whatever you want. You can refinance, you can sell, you can do all that. But when you've contracted away to the right to possession, you're agreeing to comply with a variety of rules related to the landlord-tenant relationship. So an eviction, before there was, before there was an eviction statute, to evict a tenant in possession, there was a long drawn out process called ejectment. It would take, probably over a year or longer to recover possession of real property. But most state legislatures have adopted a statutory process. They have said, we agree that the possession of real property is an important thing, and we want to give owners an opportunity to get into court on a summary basis, to get into court quite quickly. But the trade-off is that it's a strict compliance statute. So if any deviation from the lease or the eviction statute in the note in the process can be a defense to a tenant. And so that's the tension, right? You get into court a lot faster than you say would if you had a personal injury case, but you got to really cross your T's and dot your I's is often what we say. But generally, a tenancy will fall into one of two categories. Either you have a lease where the terms of the lease will control how to evict a tenant or what you might be entitled to do. Or if the lease has expired or there never was a lease, they would be what's called a tenant at will. And I'll take the next one. Okay, so eviction process. So generally, most modern courts disfavor what's called self-help. That is where the landlord just decides to either change the locks on a tenant or turn off the utilities. There's an expectation that the landlords will follow the proper judicial process. So generally, these are the steps. It almost always starts with what's called a notice to quit. And it has to comply with the lease if there is one, or the tenancy at will statute. You have to wait for the notice period stated, whether it's a 7-day or a 30-day notice to expire. And then the landlord can get what's called the summons and complaint. That's what will have the court date on it. And that has to be served on the tenants by the sheriff's department. It will set a return date for court. It's got to be about 14 days after it's served. And on your court return date, the judge will take attendance to make sure that the landlord and the tenant have showed up to court. Assuming both parties are there, the case will be, there's an expectation that the parties try to settle their case. And I'll talk more about potential settlements in a minute. And if the case can't settle, there's often a trial that day. If it went to trial and the landlord prevailed, they would get a judgment that day. And then 7 days later, they can get what's called the writ of possession, which would need to be served by the sheriff's department. And then the tenant has 48 hours to vacate after service of the writ. If it went to trial and the tenant prevailed, generally the landlord is going to have to start over with a new notice to quit. So the notice to quit, right, again, what type of notice to give is going to depend on whether the tenant has a lease or not. But generally, like, if you're going to evict the tenant who has a lease for certain conduct, the lease has to have a provision that provides for an eviction for that conduct. And some leases have a two-step notice process. Some leases, so I guess what I would say is you really got to read the lease and see what it provides for. If there is no lease for a tenant at will, let's say, generally a tenant at will can be evicted on a 30-day no fault notice. Or if there's a cause, it's a 7-day non-payment, 7-day for damage, nuisance, or unauthorized occupant. So those, you can get into court a little faster on a 7-day, but generally there's an expectation that, you would have to prove what was alleged in the notice. And sometimes that's more difficult than you might anticipate. And that's why 30-day no cause notices are much more difficult generally for tenants to defend than a 7-day at fault notice. Okay. So when you go to court, on your return day to court, there's a docket call where that's essentially the judge taking attendance to see who's there. If the landlord hasn't showed up, if the landlord's not there, the case generally gets dismissed. If the tenant's not there, generally the landlord can get what's called a default judgment. But assuming both parties are there, there's an expectation that you'd either try to discuss it between yourselves to see if you can reach a resolution, or maybe get the help of a third-party mediator that often goes to court and will try to help parties resolve their case. And only if there's no resolution would you report back to the judge, Your Honor, we can't settle, we're prepared for a hearing. Okay. Okay, so when you go to court, there's usually really kind of 3 possible outcomes. The parties settle with what sometimes is called a pay and stay agreement. So if the issue was non-payment and the tenants, and the parties agree that they want to keep the relationship together, they just want the tenant to catch up on the rent. Generally, we have a pay and stay agreement with the expectation that the tenant would pay their regular rent on time going forward, and plus some fraction of the back rent each month until they're paid up in full. So if it's a 6-month pay and stay agreement, they would have to pay 1/6 usually of the back rent until they're square. And if they comply, then the agreement is over and they continue to be normal tenants there. Sometimes we do what's more referred to as a behave and stay agreement. So if the conduct complained of is the tenant's behavior in some way, that we can work out a probationary agreement where the tenant gets to stay, but they're kind of on, they're on probation. And if there's a violation of the behavioral terms, the landlord would have a more summary remedy to cause the eviction of the tenant at that time. And then the last category is a move-out agreement where, we agree on some sort of date certain for the tenant to move. And it generally, if the tenant complies, the case would be dismissed. But if the tenant holds over even 1 day for really any reason, then the landlord can use law enforcement to cause the physical eviction then. Again, if it doesn't settle and there's a hearing and the landlord wins, they'll get the judgment that day, but they won't be able to get the writ until 7 days later. And then with the 48 hours of service, we often say 9 days before, that's worst case scenario from the tenant, that the writ is issued 7 days later and it gets served the same day. And then they would have 48 hours from that. So we often say 9 days. If there's a hearing and the tenant wins, generally the landlord would have to start over with a new notice to quit that either complies with the lease or the tenancy at will statute. And so they'd have to wait for the notice period to expire, get a new summons and complaint, use sheriff's department and pay sheriff's department again to serve the summons and complaint again. So what often happens is, both sides kind of cut bait, I guess, or take recognize the risk associated with a hearing and can often reach a settlement. I mean, statistically, well over 90% of cases settle, very few go to hearing. But okay, so here's some kind of special topics, I guess. So what's an illegal eviction? An illegal eviction is generally trying to recover possession of the property without going through the court process. So this can include cutting off their utilities, their access to the rental unit, their access to personal property without using the court process. The tenant has some remedies if that happens. Generally involves an injunctive relief, or that is an order from the judge to restore the tenant to possession. The tenant may be able to get their damages, which could be their actual damages, or $250, whichever is greater. Costs associated with the getting back into possession and attorney's fees. So just that's all of this, I guess, is kind of a little pitch to please don't do illegal evictions and just follow the court process. Landlord access, this often comes up too. The general rule is that landlords must provide reasonable written notice. 24 hours is presumed to be reasonable. There is an exception for emergencies. So if there's flooding or fire, then no written notice would be expected in that situation. And then the tenant would have some remedies in this type of situation, either the actual damages or, I guess the damages are so paltry, to be completely frank, that for most tenants, 1 or 2 improper entries by a landlord is probably not going to get anybody fired up enough to go through all the work of filing an actual case. Okay. Okay, another thing is even after a tenant either moves out, or let's just say the tenant went to a hearing and got a judgment they lost, and the judgment issued and they got evicted by the sheriff, the landlord is not free to immediately dispose of the tenant's personal property. Generally, the landlord has to provide a written notice to the tenant's last known address that they have 7 days to claim the property before or will be disposed of. And if the tenant it indicates an interest or that they do claim it, they have about 7 days to actually come physically pick it up before it can be disposed of. So this type of right to abandon property notice can't be waived in the lease, but it is something that is almost always waived if there's an eviction case with a settlement, because the landlord doesn't want to comply, doesn't want to go through the rigmarole of that notice, and the tenants are willing to give up that generally as part of getting the settlement done. And okay, so rent increases. So Maine does not put any caps on how much a landlord can increase the rent, but there is requirements about how much notice the tenant's entitled to. So if the rent increase is less than 10%, it's a 45-day notice right now. If the rent increase is 10% or more, or if it's a second rent increase that will make it 10% or more in a 12-month period, then that notice requires a 75 days notice. And if the rent is increased improperly, the tenant can generally claw back the difference, the overpayments that were made, or if the rent was increased improperly and then the tenant doesn't pay it, that could be a defense to a non-payment case for not paying an improperly increased amount of rent. And if there's warranty of habitability violations, the statute says the landlords cannot increase the rent. Sorry, I gotta sneeze, I thought. Okay, I'm okay. And I think that's it. That's kind of the evictions and tenancies 101. I don't know if we're doing questions or not, but that's all I got.
Thank you so much, Mike. That was a ton of information in a short period. Sorry to slam you in there at the end. That was a lot of great information though and good slides. Since we have run out of time, what we're going to do is collect questions and get back to people via email in a matter of everyone's time here since we are on our 1 hour with the library. So I just want to remind folks, if I'm able to do it here real quick, just to share that we do have some other webinars coming up this month. And hopefully we'll be able to, let me see if I can share my screen real quick. Share with you that, nope, I'm not able to do it, but we have more webinars coming up. The next one will be on accessory dwelling units next month. So that'll be July 24th from 12 to 1, and we'll be talking about accessory dwelling units. We have some presenters from Kenny Bunk Savings and Northeast Credit Union talk about some great products they've put out to help folks get over the hurdle of pulling a loan to create those units, as well as some local presenters, either code or planners, to talk about how to create accessory dwelling units and what the requirements are in town. And then lastly, we'll be taking a quick look at Kittery's model on creating an ADU grant program if other towns are interested in replicating that. So I want to thank everybody for their time, particularly the presenters, Elaine, Julie, and Mike. Thank you so much. I apologize for the IT glitches, but we'll be sure to get those fixed and get this email out to everybody. So thank you so much for your time and have a great day. Thank you.
Bye.